Be ready. Start. The action of the magistrate, inasmuch as it sought the specimen writing of the accused to be sent in the first instance to the government expert for his opinion and evidence, far from being prohibited, was consistent with the principle enunciated by the Bombay High Court. Stop. In the instant case, the magistrate has the extract from his order dated May 20, 1972, shows after considering the peculiar circumstances of the case and recalling the observation of the Calcutta High Court in Hira Lal Agarwal versus State to the effect that Section 73 entitled the court to assist itself for a proper conclusion in the interest of justice expressly applied this test to the present case. Stop. The peculiar circumstances which weighed with the magistrate in directing the accused to execute sample writing to be compared in the first instance by the government expert of questioned documents included the contumacious conduct of the accused and the resiling of the material witness Tek Chand, which according to Mr. Marwa was possibly due to his having been suborned or won over by the accused. Stop. It was apparent from the record that the accused was playing hide and seek with the process of law and was avoiding to appear and give his sample writing to the police. Stop. The magistrate therefore had good reason to hold that the assistance of the government expert of questioned documents was essential in the interest of justice to enable the magistrate to compare the sample and the question writings with the expert assistance so obtained and then to reach a just and correct conclusion about their identity. Stop. Although the order of the magistrate is somewhat inartistically worded, its substance was clear that although initially the specimen writing sought from the accused was to be used for comparison by the government expert, the ultimate purpose was to enable the court to compare that specimen writing with the disputed one, Exhibit PW 21F, to reach a just decision. Stop. In the revision petition filed by the accused before the High Court, a grievance is sought to be made out that the magistrate's order will work prejudice to the defense and enable the prosecution to fill gaps and loopholes in its case. Stop. This contention was devoid of force. Stop. Once a magistrate in session of a case duly forms an opinion that the assistance of an expert is essential to enable the court to arrive at a just determination of the issue of the identity of the disputed writing, the fact that this may result in the filling of loopholes in the prosecution case is purely a subsidiary factor which must give way to the paramount consideration of doing justice. Stop. Moreover, it could not be predicted at this stage whether the opinion of the government expert of questioned documents would go in favor of the prosecution or the defense. Stop. The argument raised before the High Court was thus purely speculative. Stop. In addition to Section 73, there are two other provisions resting on the same principle, namely Section 165 Evidence Act and Section 540 CRPC 1898, which between them invest the court with a wide discretion to call and examine anyone as a witness if it is bona fide of the opinion that his examination is necessary for a just decision of the case. Stop. In passing the order which he did, the magistrate was acting well within the bounds of this principle. Stop. The matter can be viewed from another angle also. Stop. Although there is no legal bar to the judge using his own eyes to compare the disputed writing with the admitted writing, even without the aid of the evidence of any handwriting expert, the judge should, as a matter of prudence and caution, hesitate to base his finding with regard to the identity of a handwriting which forms the sheet anchor of the prosecution case against a person accused of an offense solely on comparison made by himself. Stop. Stanza. It is therefore not advisable that a judge should take upon himself the task of comparing the admitted writing with the disputed one to find out whether the two agree with each other, and the prudent course is to obtain the opinion and assistance of an expert. Stop. It is not the province of the expert to act as judge or jury. Stop. As rightly pointed out in Titli versus Jones within bracket 1, the real function of the expert is to put before the court all the materials together with reasons which induce him to come to the conclusion, so that the court, although not an expert, may form its own judgment by its own observation of those materials. Stop. Ordinarily, it is not proper for the court to ask the expert to give his finding upon any of the issues, whether of law or fact, because strictly speaking, such issues are for the court or jury to determine. Stop. The handwriting expert's function is to opine after a scientific comparison of the disputed writing with the proved and oblique or admitted writing with regard to the points of similarity or oblique and dissimilarity in the two sets of writings. Stop. The court should then compare the handwritings with its own eyes for a proper assessment of the value of the total evidence. Stop. Over.